motion for summary judgment. This case was filed in December of 2020, and the Cordova family, a widow and 2 children, is entitled to a ruling. The basic issue before the court is that Mr. Martin asked for discovery. He was awarded and got the discovery, and then he abandoned discovery. The first I want to state is that there's a motion by the defendant to continue this hearing procedurally. That's dead on arrival.
A brand new courtroom in Cheatham County, Tennessee. The morning light coming through fresh windows. Judge Wolf behind the bench for the very first time in this room. He had already joked that sitting in that chair made him feel like he was on the bridge of the Starship Enterprise.
Call for Cheatham County in our brand new courtroom. First time that we'll have held the circuit civil docket call here, and so we're thankful for having such a nice courtroom. I told somebody the other day that I felt like I was on the bridge of the Starship Enterprise when I sit behind this desk and in this chair, but I'm thankful that we have a better sound system and a better lighting and so forth. I love the old courtroom, but it is difficult sometimes to conduct business because of the acoustics, if nothing else. So.
One case had been waiting 5.5 years for a ruling. A widow and her 2 children were on one side. An attorney named Robert Martin was on the other. And the question before the court was whether that attorney had spent nearly 7.5 years pursuing a legal claim he had already admitted, under oath, that he had no ethical right to pursue. Here is how it started.
Your Honor, this morning, I think the best way for us to handle this, there's 4 separate matters on behalf of the plaintiffs and 4 separate matters that have been filed by the defendant, Mr. Martin. We would state that on March 3rd, 2025, this court gave Mr. Martin exactly what he asked for, the deposition of Ms. Cordova before any ruling on our pending summary judgment. For 13 months, Mr. Martin did nothing. The only thing that woke this case up was plaintiff's recent motion, noticing their renewed motion for the hearing on the summary judgment that's been pending since March of last year.
A woman named Cordova had been represented in a legal matter years earlier by an attorney. When that case concluded, she received a recovery. Robert Martin believed he was owed a portion of that recovery as a fee. He filed a lien against her to collect it. The problem was that Tennessee law is very specific. An attorney cannot enforce a contingency fee arrangement unless that agreement is in writing and signed by the client. Martin had no written agreement with the Cordova family. He had an agreement with another attorney named Hyjays, not with the client herself. This is not a disputed fact. Martin admitted it himself during his own deposition on November 23rd, 2021. He acknowledged violating Professional Conduct Rules 1.5c and 1.5ie. Those rules require written signed contingency fee agreements. He said under oath that he had broken them.
Mr. Martin's own sworn deposition admissions, and that was during his November 23rd, 2021 deposition. And we've cited in our brief that those are pages 151, lines 16 through 23, page 153, lines 2 through 16. Where he states that under Rule 1.5c and 1.5e, he committed ethical violations. B, the Court of Appeals, their findings, they found that he had abandoned and that the plaintiffs were the prevailing party against his claim.
And then he kept the lawsuit going. That is the core of what brought this case before Judge Wolf on this particular morning. Cordova's attorneys had filed a motion for summary judgment. They argued that the record was already complete. Martin had admitted the ethics violations. The Court of Appeals had already found, in a prior proceeding, that he had no fee agreement with the plaintiffs, only with Hyjays. Every dollar Martin had ever claimed from the Cordova family had been wrongfully claimed from a widow and her 2 minor children.
That is precisely why Martin had to file his lien against the Cordovas. You don't file a lien on your own money. The Court of Appeals found he had no agreement with them, so every dollar he claimed was wrongfully claimed from the widow and her 2 minors. And no, quote, tied up anyway story explains the later 11-4-22 lawsuit that he filed against Miss Cordova personally, making her a party twice by choice. So the
The motion for summary judgment had actually been pending since September of 2024. That was 21 months by the time of this hearing. Back in March of 2025, the judge had given Martin additional time, specifically to take the deposition of Mrs. Cordova before any ruling. That was a significant accommodation. The court essentially paused the entire proceeding in his favor.
The case was filed in December 2020, 5.5 years. The MSJ has been pending since September 19th of 2024. That's 21 months at this point. The court deferred the ruling on March 3rd, 2025, solely so the defendant could depose Ms. Cordova. For 13 months, they did nothing, and under Rye, adequate time has passed. The record is what it is, and, quote, he asked.
13 months passed. Martin's side did nothing. Then, 16 days after Cordova's attorneys renewed their motion for summary judgment, a single envelope arrived at their office by U.S. mail. Inside was a deposition notice for Mrs. Cordova. Written discovery requests a scheduling motion and a motion to disqualify all of Cordova's attorneys.
16 days later, a single envelope arrived at my office via U.S. mail containing a deposition notice for Ms. Cordova, written discovery and a scheduling motion, and a motion to disqualify all of Ms. Cordova's attorneys, including myself. Every motion that Mr. Martin brings today through Mr. Olson is a piece of that same package, and it has one purpose: to make sure this court never rules on our.
Cordova's attorney addressed this directly in open court. He told Judge Wolf that every motion arriving in that envelope had one purpose: to make sure the court never ruled on the summary judgment motion. He pointed out that the motion to disqualify was filed under a rule that applies only at trial, not during pre-trial motions, and that the disqualification request itself even admitted, in its own language, that the whole package was pressure in response to the renewed motion. The document actually used the word pressure. The attorney quoted it directly into the record. Martin's attorney, Mr. Olson, responded with a different account.
She didn't testify there. I have sought to depose her on 3 different occasions. 3, not once, but 3 different occasions, and she has never shown up, period. I have sought from counsel who is here today dates that we would go forward with this deposition, and she has never shown up. Ultimately, we noticed up a deposition because we were never able to get a deposition that would be sufficient to opposing counsel. At this point, I legitimately wonder if Ms. Cordova knows a lot about this. And I wonder if she
knows a lot about what?
About this civil action, because there has been a specific action on the part of counsel to not allow Ms. Cordova to be questioned.
He told the court that he had tried on 3 separate occasions to schedule Cordova's deposition and that her attorneys had refused each time, insisting on specific conditions that were never met. He said he had even secured a room at the Cheatham County courthouse for the deposition, and that opposing counsel had declined that too.
So when it's presented that there's been 13 months and that the first effort you've made to try to depose Ms. Cordova was earlier in the month of June, is that accurate as far as you're concerned?
No. I tried to get them to come to Clarksville. Miss Cordova, we sought her out and we found her. She lives in Montgomery County. This case, as Your Honor knows, is a Montgomery County case. It was transferred from Montgomery County to Cheatham County. She lives there. I called and said, hey, look, actually, I don't really talk to counsel. We communicate back and forth. I said, we really want to go ahead and I've got this date and I've got this date. Let's come up and do this deposition. No, we're not going to do it. Has to be done specifically on terms that we say at our office.
He argued that without her testimony, he could not properly respond to the summary judgment motion because her state of mind and her alleged oral agreement with Martin were essential to his defense. Cordova's attorney pushed back hard on that claim. He told the court that none of those alleged attempts appeared anywhere in the record. No affidavit had been filed. No emails had been submitted. If those efforts had actually happened, he said, They would exist somewhere in the court file. They did not.
All of these claims about how he's tried to take Ms. Cordova, where is it before the court? All these things should be before the court in the record, and I would submit that they're not. What he's trying to do is confuse the court. He's talking about the Cordova versus Nashville Ready Mix case. That's a case that occurred before Judge Wallace. It was settled on an offer of judgment, has separate facts, and was only settled with Mr. Hodges and his estate. Those are separate facts in a separate case. It's not before Your Honor. This is a case of malicious prosecution by the Cordova family against Mr. Martin. Has nothing to do. So his statement that he's been trying to take Ms. Cordova's deposition for all this time and relating it to this other case that's not before Your Honor is just, it's wrong, and it's not before the court. And no evidence, no affidavit has been filed. If counsel wanted to file an affidavit saying, Your Honor, on this date I did this, and I did this, and I did this, he would be able to do it. He didn't.
Then he made the argument that cut to the center of the case. He told Judge Wolf that nothing Mrs. Cordova could say at a deposition would change the outcome.
Because we know that it is an ethical violation for an attorney to charge a contingency fee without a contract. And where did Mr. Martin go wrong in this case? Knowing that and admitting to that, he decided to still go ahead and sue his former client and pursue that litigation for 7.5 years.
The summary judgment motion rested entirely on Martin's own sworn admissions and the Court of Appeals' factual findings. No testimony could unadmit a rule violation that Martin had already confirmed on the record. The question of probable cause, the attorney argued, was not a jury question here because the material facts were not in dispute. A written fee agreement either exists or it does not. Martin had admitted it did not exist. The Court of Appeals had confirmed it. That was a question of law, not fact.
Even accepting that Ms. Cordova orally consented, as Mr. Martin claims, to his involvement, oral consent is not a legally enforceable contingency fee arrangement under Tennessee law and cannot supply probable cause for a lien. The Court of Appeals has already foreclosed this and found, quote, all the services Mr. Martin subsequently rendered inured to the benefit of the plaintiff. He never had a fee agreements with plaintiffs, only with Mr. Hodges. And I'm citing from the third page of the Court of Appeals findings. An affidavit restating a rejected legal conclusion is not evidence, Your Honor.
On the question of malice, he argued that 7.5 years of pursuing a claim you have already admitted was unethical is itself the evidence of malice. Malice, under Tennessee law, does not require proof of ill will. It can be inferred from the absence of probable cause and from an improper motive.
Defeat summary judgment. Malice is inferred from want of probable cause and improper motive. Ill will is not required. We cite the Cohen versus Cook case, 462 Southwest 2nd, 502, and that's a Tennessee Court of Appeals case from 1969. We also cite the Howell versus United Rentals case, which is a 2023 Tennessee Appeals Court case found at Lexus 374. Course of conduct, the approximate 6-year lien pursuit by Mr. Martin, despite knowing that it was unethical and he had no written agreement to pursue it. And then subsequently after that, through Mr. Olson, he filed a second retaliatory suit against Ms. Cordova and all of her attorneys. He filed that case on November 4th, 2022, and then voluntarily dismissed it after.
A man who knowingly pursues an unenforceable lien against a client for nearly a decade, and then files a second lawsuit against that same client personally, and then voluntarily dismisses it 13 months later, has provided that inference through his own conduct. The numbers he laid out were precise.
Today, because we're just talking about liability. Did you violate the ethics rules with malice? That malice decision is you pursuing it for 6 years, knowing that it was unethical. So it's proven by Mr. Martin's own sworn admissions. Again, I'll point to his November 23rd, 2021 deposition, his admissions, the Court of Appeals findings, and the duration of his wrongful pursuit. July 2024, he admitted through January 14th of 2022. That's when he stopped and withdrew his claim. So the total is actually approximately 7.5 years. I apologize. And that's established entirely by the court's own records. We have filings, the orders, the hearing dates, the special master.
40, 2 substantive filings during the period Martin was actively pursuing his claim. Only 12 after he withdrew, 4 court orders during his pursuit, 2 afterward, 5 hearings with transcripts during that period, 1 afterward. The arithmetic, the attorney said, was not a narrative. The docket itself proved the duration. The admissions proved the malice. The records proved the cost.
As we've identified. So, Your Honor, the damages here are arithmetic. They're not a narrative. The docket proves the duration. His admissions proves the malice. And the records prove the cost. There is nothing Ms. Cordova could say at a deposition that would add or subtract from any of those numbers. So respectfully, we would ask that the
Judge Wolf listened carefully through all of it. He was measured and direct. He acknowledged that both sides had their versions of why the Cordova deposition had never happened.
We can go back and forth about this all day. Both of you have your positions, and this is the case I've heard before. And I granted some additional time to the defendant to depose or do the discovery. Obviously, both of you have versions about why there was no discovery deposition of Ms. Cordova. Unfortunately, she is the plaintiff in the case, and therefore I think the defendant would be entitled to take her deposition. But I agree that a 13-month delay is, in my opinion,
He also noted that he was aware Olson had experienced some health issues that had affected his ability to be timely in certain cases. And then the judge did something that surprised Cordova's team.
time. I know that Mr. Olson's had some health issues, and other cases I'm aware of the fact that he's had those issues that have affected his ability to be as timely as perhaps he should have been in some cases. Having that knowledge, I'm inclined to grant him one opportunity to discover that. So I'm going to order that within the next 10 days, you arrive at a date for a deposition. The deposition will be taken here. I'm saying within 10 days, you set a date for a deposition. Once that deposition is taken, then you may come back, you may contact me, and we'll find a day to shoehorn you in.
He declined to rule on the summary judgment that morning. Instead, he ordered both sides to schedule Cordova's deposition within 10 days. He directed that it be taken here at the new courthouse, in a room that could be arranged through the clerk's office. Once the deposition was completed, he would set a new hearing date for the summary judgment motion. He set one firm condition. The scope of that deposition would remain exactly as he had defined it in his March 2020 5 order. Martin's state of mind and conduct were fair territory. No privileged communications.
I would also ask that the court just restate that the limitations on her deposition that were found back in March of last
Whatever
year
the
still-
limitations were on the deposition that I set in the original order granting the deposition continue for this deposition. So they need to be restated.
Yeah, and I think, Your Honor, what I wrote down here is that Martin's state of mind and conduct are the issues that can be talked about. No privileged communications and no communications with attorneys. So that was what Your Honor made the scope of it.
Whatever I said initially.
Okay.
No questions about what Cordova discussed with her attorneys. He looked at both lawyers standing before him and said something.
Well, both of you seem so reasonable when you're standing right here. What I perceive, and having done this for as long as I have, is I perceive that when you walk outside of those doors, you're not necessarily going to be as agreeable with each other. So I'm just simply telling you the way we're going to do it. You got 10 days to set that date. Both of you find a date to do this deposition within the near future. I'm not setting it. It has to be 30 days, 60 days, whatever. But I want a deposition scheduled with all of the necessary situation scheduled here.
That carried its own quiet weight. He told them that they both seemed very reasonable when they were standing right there in front of him, and that when they walked out those doors, they were not necessarily going to be as agreeable with each other. He was not wrong about that. The case had now been active since December of 2020. That is 5.5 years. The summary judgment motion had been pending for 21 of those months. A widow whose husband had already died, who had already fought through years of litigation, who had already prevailed before the Court of Appeals, was still waiting for a final ruling on a claim the opposing attorney had confessed under oath was built on an ethics violation. That is not a technicality. That is the structure of the process itself. Legal accountability often moves through exactly this kind of friction. The rules exist. The admissions exist. The record exists. And still the machinery requires more time, more hearings, more depositions, more orders. Each step is individually defensible. The accumulation of those steps is something else entirely. What this case reflects is a truth that courtrooms like this one encounter regularly. The existence of a rule and the enforcement of that rule are not the same event. An attorney can admit wrongdoing on the record and still spend years inside the system before that admission produces a consequence. The process does not accelerate simply because the answer seems clear. It moves at the speed the rules allow. And sometimes the rules allow a very long time. Mrs. Cordova came into this as a client. Then she became a plaintiff. Then she became a defendant in a second lawsuit Martin filed against her personally. Then that case was dismissed. And still she was waiting. Judge Wolf's new courtroom was bright and modern and full of natural light. The audience watching the live stream that morning noticed it immediately. The old courtroom had difficult acoustics. This one had better sound and better lighting. The judge said he was grateful for it. The proceedings were going to continue. The deposition would be scheduled. The motion would eventually be heard, and somewhere in all of that, a widow and her 2 children would find out whether the legal system considers 7.5 years of an admitted ethics violation to be enough.